Buenas and Hafa. The Committee on Health, Land, Justice, and Culture is now called to order. It is Wednesday, September 21st, 2022. The time is now 9:35. In compliance with open government law, notices for this public hearing were published in the Guam Daily Post Wednesday, September 14th, and Monday, September 19th. It was also posted in the Government of Guam public notice portal and is live streamed in the Guam Legislature's YouTube channel. Notices were sent via email to all senators and all main media broadcasting outlets. Individuals testifying shall first be recognized by the chair before speaking and begin by stating their names for record-keeping purposes. The agenda item that will be heard today is Bill 313-36 COR, sponsored by Senator Mary Camacho Torres, co-sponsored by Vice Speaker Tina Rose Muña, Senators Christopher Dueñas, Jose Pedo Terlaje, Telena Nelson, James Moylan, Tony Ada, Frank Blas Jr., Joe Agustin, Amanda L. Shelton, and Sabina Perez. It's an act to add a new chapter 40A to Title VII Guam Code Annotated relative to establishing a protection order for a person who is a victim of non-consensual sexual contact or non-consensual sexual penetration. I'd like to acknowledge my colleagues who are here today, Senator Mary Camacho Torres, Senator Terlaje Taitigui, and Vice Speaker Tina Rose Muña. And now to begin our agenda on Bill 313-36 COR, sponsored by Senator Mary Camacho Torres and co-sponsored by Tina Rose Muña, Christopher M. Dueñas, Jose Pedo Terlaje, Telena Nelson, James Moylan, Tony Ada, Frank Blas Jr., Joe Agustin, Amanda Shelton, Sabina Perez. An act to add a new section, to add a new chapter 40A to Title VII Guam Code Annotated relative to establishing a protection order for a person who is a victim of non-consensual sexual contact or non-consensual sexual penetration. For the record, other stakeholders were invited to provide feedback, which includes Guam Bar Association members, Guam Coalition Against Sexual Assault and Family Violence and their partners, the Department of Public Health and Social Services, the Guam Police Department, Victims Advocates Reaching Out, or VERO, and the Office of Attorney General. I would like to invite the sponsor of the bill to provide opening remarks. Senator Mary Torres.
Thank you, Madam Chair. Bill number 313-36 COR is an act to add a new chapter 40A to Title VII Guam Code Annotated relative to establishing a protection order for a person who is a victim of non-consensual sexual contact or non-consensual sexual penetration. Madam Chair, I introduced this measure in response to concerns raised by the Office of the Attorney General earlier this year. At a public hearing held by your committee in April, Deputy Attorney General Nishihara noted that, according to local service providers, victims of sexual assault are not eligible to use the protective order process under current law. That's because under Guam's Protection from Abuse statute, which is 7 GCA, Section 40101, only a person alleging specific acts of abuse, such as bodily injury, attempting to cause bodily injury, fear of bodily injury, or sexual abuse of a minor, may be granted court-ordered protection from their offender. These standards have made it challenging for victims of other forms of abuse to obtain a stay-away order through the legal system. The former prosecutor and head of Guam's Family and Sex Crimes Unit, Attorney Christine Tenorio, echoed the same concern during the hearing, stating that it is more difficult for a sexual assault victim to get a restraining order on Guam. According to Attorney Tenorio, the courts are looking for physical injury. You would think that a sexual assault equates to physical injury, but that's not really how the courts interpret that, she stated. To resolve this, Bill 313 authorizes a separate protection order for a victim of non-consensual sexual contact or penetration as defined in 9 GCA Chapter 25. Under the bill, no fees for filing or services of process may be charged by a public agency to petitioners asking relief and seeking relief. Petitioner shall also be provided the necessary number of certified copies at no cost. In keeping with our recently enacted mental incapacitation law, the court cannot deny a remedy based on evidence that the victim was intoxicated. Further, if the court finds that the perpetrator's conduct involved the use or threatened use of violence with a firearm, the court may order the perpetrator to surrender all firearms and other dangerous weapons to prevent further potential harm to themselves or the victim. Madam Chair, victims of sexual assault are often subjected to shame and degradation in addition to physical and emotional pain. And while reporting is encouraged, those who choose not to come forward are still entitled to protection from their perpetrator. Moreover, even when rape is reported, the perpetrator is not always brought to justice. Restricting an offender's contact with the victim in certain cases should be possible through a civil remedy. Bill 313 does this by authorizing an important tool for Guam's victims. I thank my colleagues for their support, and I look forward to feedback from our stakeholders. Sizus Maasi.
Thank you so much, Senator Torres. So preliminary review was issued by the legislature's Legal Bureau with stylistic and formatting recommendations thus far. Regards to the Bureau of Budget and Management Research, fiscal impact, it states that although this bill seems administrative in nature, correspondence with the judiciary of Guam indicates that a minuscule fiscal impact may be felt on operations. The judiciary assumes that an additional clerk may be needed upon adoption and implementation of this bill. Based on the information provided by the judiciary, the total estimated fiscal impact combined with another proposed bill, 314, which we'll hear later, is $55,564. Of this amount, $28,595 will be from personnel services and $21,969 from benefits, and $5,000 for equipment and supplies. And so some questions are that, so in the proposed definition sections of this section of this bill, 40A 101, so there is a definition for sexual contact. And so with this current bill, there is added language to the definition of sexual contact that doesn't appear in 9 GCA Chapter 25. This additional language is any intentional display of the victim's or respondent's genitals, anus, or breast for the purposes of sexual arousal of gratification. And so I guess the question is, is there an intention to harmonize the codification of this particular definition with 9 GCA Chapter 25? And yes, I would like to pose the question to the sponsor.
Thank you, Madam Chair. I want to point out that that Bill 313 contemplates a civil action, so the standard here is different from a criminal action. But we want to note, though, that with regard to F2, under the definition of sexual contact, that language is actually already contained in another part of Guam Code under 9 GCA Chapter 28, which describes indecent exposure defined and punish. A person commits a crime of indecent exposure if he or she intentionally exposes their genitals, etc. So we believe that this language is already consistent with Guam Code, and although not in Section 25, as you earlier noted, it is in fact contained in Section 28.
Masi. Another question. So there's in section of the bill 40A 106. Sorry, my apologies. I need to allow Attorney Summerflecht, my apologies. I would like to invite you to provide your testimony.
Okay. This bill is overdue. We have protected children in our prior protective order statute, but we have not protected adult victims of sexual abuse. This is a bill that I've been bugging the Attorney General's office regarding because they're more capable and don't need to worry about the lobbying issue as a federally funded agency. Lobbying is something I'm pretty much forbidden from doing. But I am allowed to come and educate. And as has been brought up, I was brought out here initially by Guam Legal Services to represent victims of family violence. The definitions of family violence was changed, and our response to it was changed back in 2007 when we initially passed the protective order statute that we currently operate under. But doesn't cover everything. As someone who's gone to court for 30 years on these issues, this is something we need in our community very much. We need to provide protection from sexual assault. As it currently is, as I mentioned earlier, we have to file for a civil restraining order, which potentially blocks victims from seeking further remedies at a later time. There is nothing worse in my practice than saying to a victim, you probably don't want to do this, or you need to consider this because this is a consequence of your doing this, particularly where the need to be protected is there. The difficulty in our current statute, as many courts have expressed to me over the years, show me the blood. It may sound cold, it may sound callous, but that's really what protective orders are focusing on. Focusing on one individual beating up and physically harming another. This brings us to a new direction. This brings us to a direction that says, no, it's not appropriate to grab people physically. No, it's not appropriate to be the slob who makes comments and grabs at women or grabs at men, who exposes themselves and laughs about it. This says that that behavior is not acceptable in our community. This says that if someone grabs at you, if someone paws you, if someone, God forbid, sexually assaults you, you can seek protection of the courts and keep that person away from you. What do most victims want? They want to have nothing to do with the perpetrator. They don't want them near them. They don't want them near their house. They don't want them near their children. They don't want them near their work site. And each time that occurs, it inflicts upon them additional trauma. This bill, in my thought process, provides the protection that we need to protect victims of sexual assault, but also provides a moral standard, a moral sexual standard in our community, and allows victims where people have not followed that standard to seek remedy to prevent that individual from being around them. This bill, to me, is vital to our community. It fills the gap that we currently have. To say that our protective orders are only good for children who are victims of sexual assault has always been a difficult dilemma to me, because so many individuals seek protective orders based upon exactly what's brought up in this bill. He exposed himself. He grabbed me. He grabbed me in places that shouldn't be grabbed by a stranger. This bill says a standard to our community that this behavior is not acceptable. And if you think that you can do it, the court has another, our legislature and our courts have another word for that, and that is absolutely not. Now, while we have criminal statutes that cover a majority of what's brought up here, many victims don't seek criminal remedies. Many victims do not want to go through long and involved trials, prosecutions, and everything else that goes on in the criminal setting. I'm able to obtain a temporary order the same day I file. I'm able to obtain a protective order for up to 5 years in most cases within 10 days or less of when I file. The courts at this point are accommodating these cases to an incredible degree. I can file on a Tuesday and be in court on a Friday in a number of cases where we're seeking protective orders on the behalf of victims. These are the most vulnerable victims. These are the victims that I believe need the greatest amount of care and assistance in our community, and this bill looks to start providing it. There is no income restrictions in our office anymore. We're able to assist any victim of violence, sexual assault, or stalking. This gives me the tool that I need to provide that assistance in a way where I'm not compromising the victims in other ways. So were I able to say I support this bill, I think my message is fairly clear. This is a bill that helps victims of sexual assault, but more so, this is a bill that says these are the standards in our community, and changes, in my mind's eye, creates a paradigm shift in how we look at sexual assault. And I believe that it's long overdue. I would thank you very much for the opportunity to speak on this, and I would thank both the sponsor of this bill and our Attorney General, Levin Camacho, for pursuing this issue. It's always gratifying to know that when you bug someone, they might actually do something. And in this case, we have now this bill in front of us. So there are many people, I believe, that I'm thankful for having this. And I believe that it creates the paradigm shift in our community that numerous women have been waiting for, as well as men. Thank you very much.
Thank you so much, Attorney Summerfleck, for your testimony. Yes, so in our community, there are, we see these instances of sexual contact even in our youth. And that's what this bill does. It will allow for protection orders for petitioners, whether or not, including when petitioners or the respondent is a minor. And I think also what's important in your experience, how does, I think, in order to make this more effective, I think, these protection orders to be more effective, there has to be an element of therapy for both parties, as well as, the community education. And so how can we make this more robust? How can we make, the requirement of therapy or, community education, how can we make this more robust to supplement what this bill is aiming to do?
With regard to the community education, the passage of this bill is a step of community education. As I previously mentioned, we as a community look toward you all to create policy, to move us forward as a community as to what is acceptable behavior, what is not acceptable behavior. I don't mean to bring up age, but I know that, a few of us here are getting up at past 60, and I look back at my youth and my childhood and how I was raised. And I don't know that this was in existence, this thought process was in existence, that this sort of behavior was shunned. And now, by passing this legislation, we clearly come forward and say, this behavior is absolutely unacceptable in our community. We are going through changes in our society with the Me Too movement, and this bill goes hand in hand to say that as a community, Guam is not going to accept grabbing of people's parts. Guam is not going to accept that former attitude we had that this is all yuck, yuck, yuck. This is now, that in and of itself, in my mind's eye, when this bill passes, as I hope it will, to send a message to the community that this is not appropriate behavior. And we as a community, including organizations like myself, like the coalition, can then go forward and make it clear everywhere that this behavior is not acceptable, including so many aspects that we don't even realize are going on. To say to a victim that you don't have to be grabbed and you don't have to put up with it and you don't have to smile and move on as quick as you can, says that we're done with that phase here on Guam. That women and men have a right to the integrity of their bodies and have a right to not be sexually assaulted by individuals who think it's funny to do things like exposing themselves. This makes a very clear line in our community and provides a very clear remedy to individuals to say no more. No more of this behavior. As far as counseling, there is counseling available through the courts. There is counseling available through the community. To encourage that sort of counseling, we could strengthen the bill and have them referred, like we do for drugs, for an assessment to determine whether we're dealing with an individual who thinks this is all a game. And I don't bring this up lightly. I don't believe that there's a lot of individuals in our community that consider this some kind of game, but I do believe there's a good percentage, and we need to eliminate that. But as far as the counseling is concerned, I think the better message is by passing this law and saying this is not acceptable and providing a means for individuals to come forward and say no more to this.
Thank you for that. So just to kind of clarify the question, do you see any conflicts in requiring therapy through protective orders, in your legal experience? Is there an issue with that?
No.
Okay.
Ordinarily, the relationship between a therapist and a client is considered confidential already. I don't, for the perpetrator, there may be issues about making statements to a counselor, particularly admissions. But I believe that the better way to deal with this issue is not through incarceration. It is through counseling, particularly when we're dealing with youth. And the message, I think, is the more important aspect here, that this behavior is not acceptable in our community. And this bill defines it much cleaner than a lot of other aspects in our law. And this bill, in my opinion, provides a means for victims to have a voice without having to go through a criminal process, without having to go through a long, involved process, but to provide them a means to prevent someone from being around them who can't act appropriately.
Okay, so the, if we can just turn to the language in the bill. So in section, I don't know if you have a copy of that in front of you. Okay, in section 40A 106 under remedies. So it starts off by saying if the court finds a preponderance of evidence that the petitioner has been a victim of non-consensual sexual contact or non-consensual sexual penetration, the court shall issue an sexual offense protection order. And then later on, it goes on to say that the court, when determining whether or not to issue a sexual offense protection order, may not require proof of physical injury on the person or the victim, or proof that the petitioner has reported the sexual assault to law enforcement. So I guess in your legal experience, how can the court then proceed to order without that particular evidence? Or how do you see that working out?
I do it every day. Oftentimes, there are no bruises, there is no physical evidence. There is a statement of a victim as to what occurred, and there is an opportunity for a respondent to tell his side of the story. I would opine to you that very few people make these things up, but there may be. And this is in a civil context, and what are we doing? We're preventing them from having contact with the individual. We're keeping them away. I can't think of cases, and I'm racking my mind. I do have cases where I have bruises, where there's physical assault, but everything I file is under penalty of perjury. And it also relies upon me as an attorney ensuring that I'm presenting accurate and true facts. I don't know of many cases where I do have physical evidence. And I don't see how you would have physical evidence of someone, for lack of a better way of saying it, exposing themselves. Is it expected that the victim would take a picture of an individual exposing themselves? I don't think so. You know, a lot of what the court operates on is credibility. Does the court believe the victim and what the victim is putting forward? Does the court believe the perpetrator and what the perpetrator is putting forward? I would opine to you in a number of cases where the perpetrator is saying, I want to fight this, and then gets up on the stand. Explaining the circumstances is almost comical. The victim ran into my elbow as I was yawning. The victim ran into my fist. It doesn't take a master of credibility to sort out a lot of the defenses that come up. But I would opine that if you require physical evidence, you've just defeated your own law. Because what you're saying is the victims cannot be believed. And there usually isn't physical evidence. And even in my world, let's say the victim also filed a police report and went to Healing Hearts for a Healing Hearts examination. I don't have access to any of that. I go to court with the victim saying, I'm a victim. I've been assaulted. This person assaulted me. Sometimes they file police reports, sometimes they don't. That shouldn't have bearing on whether the court in a civil action determines whether the victim is credible. But the issue of credibility is always an issue for every court, for every lawyer. You know, I need to determine before I file a case that I have a good faith basis and I have credible evidence. Otherwise, I'm subject to being sanctioned. The judges themselves have been trained to listen to the story, to evaluate the credibility of the witnesses. So I don't see any issue with regard to providing physical evidence. I don't provide it in most cases, I argue these days anyways. I mean, if I'm lucky, I might have photos of bruises, but it's still my victim saying he's the one that bruised me.
Okay, thank you. And so basically what would kick in is this preponderance of evidence?
Yes.
Okay. All right, great.
And if I might, there's somewhat of a misnomer. And that misnomer is that all these cases go to full hearing. I would say that probably 80 to 90% of the cases never go to hearing at all. I walk up to the perpetrator, I say, "What's your position on this?" They say, "I never did it, but I'll stay away from her." And I say, "Okay, as long as you agree to the terms of the protective order, you don't have to admit that whether you did it or you didn't." If they want to go to hearing, then I say to them, "I'm a trained lawyer. I wouldn't be here if I didn't know that I had a case I would succeed in. Are you really sure you want to go in front of a judge? Because once you do, everything you say is now on the record. If you lie, you commit perjury, and it all can be used in your criminal case." So I would opine to you that, like in protective order cases I do currently, most of the perpetrators aren't going to want me to present a case. They're going to agree to stay away. And that is probably the most common that I come across. Now, the earlier bill that we just discussed may change some of those dynamics when they know that there's actually a financial aspect that they're exposed to, but I don't see it in this legislation at all. And I think the importance of this legislation outweighs any other thought process. To say that this behavior is unacceptable in our community, in my mind's eye, is key.
All right, thank you so much, Attorney Summerfleck. I'd like to open the floor to my colleagues for any questions. Senator Mary Torres.
Attorney Summerfleck, I'm so grateful for your testimony today. The practical discussion that you've had about the scenarios that we're trying to address with Bill 313, mostly that this is a victim-centered bill, a bill intended to assist victims of non-consensual sexual contact or sexual penetration. But the one statement that I'm particularly hanging on is your statement about the paradigm shift, how this bill will be a paradigm shift, similar to what was also attributed to the bill that dealt with consent and redefining consent to sexual contact, and how once we establish that mental incapacity to consent, a person who is intoxicated, even willingly intoxicated or willfully intoxicated, does not have the mental capacity to consent to sexual activity. And that was a game changer that the Attorney General's office also testified to, and other attorneys. Similarly, this bill and the other series of bills redefines what is acceptable action and what is no longer acceptable action, what will be tolerated, what will not, and what has civil remedies easily achievable by the victims. I agree with you that all else said, we must first start with policy that restarts how people see things and whether they understand that they will be held accountable for actions that are no longer tolerated, that are defined in statute as being not permissible. And so I just want to thank you again for coming out, because these sets of policies are born from and come forth from the discussions and testimonies brought forth by responsible legal practitioners such as yourself, who have the pulse of the community and who can bring those realities in a very, very practical and very understandable dialogue before the legislature. So I believe that these bills will go through and that they will be a start to now causing a downward of the what we now see as a sexual assault trajectory on our island. You know, at some point we're going to have to we're going to have that incidence, the incidences and the number of incidences decrease. And these, I believe, are the measures, the policy measures that can help with that eventual decrease of sexual assault, just by having people understand that there are limits and that there are remedies, especially for victims, practical remedies. So,
Well, I would opine, if I may, I've always considered Guam a community that's based upon respect, and this puts the level of respect to a different level. And that respect involves showing dignity and showing integrity to other people's bodies. And of all the things that I've cherished while I've lived here on Guam, it has been that thought process of respect. But I believe that we as a community need to bring forward what that term means. And this bill shows a respect to the dignity of people's own bodies, as well as a respect to the sexuality, or no sexuality, as this case would be, that's unwanted.
thank you. And oftentimes we hear Guam celebrated as a matriarchal community where women are held in high regard. And the prevalence of violence against women and children is counter to that ideal. And I hope that one day we can regain what we tout as our cultural significance, one of the attributes of being on Guam, the respect for the woman, the respect for the child, the respect for the family, the respect for each other, as you bring up. But we definitely are on a good footing right now with these series of bills. We've introduced previously the bills that establish the Victims' Bill of Rights for sexual assault. We redefine what consent was to sexual activity. And now we're going forward with civil remedies for people that need protective orders when they are violated or threatened. And I think that, in working with good people like yourself, the Attorney General, and the legal community, we can better understand and bring these policies to fruition so that we can, in fact, as you said, change the mindset and have the whole paradigm shift from where it was a society where sexual assault is prevalent and sexual deviance is prevalent to a society where respect now is more the norm than the exception. So Sidzuas Masi for that.
Thank you.
Thank you, Senator Torres. Senator Taitigui.
Again, Mr. Sonnenfeld, thank you so much for being here and testifying and your passion toward this. I know that you deal with this type of issues on a daily basis. I think this legislation is a deterrent to those individuals who think they can, violate a person's body. I've come in a situation too where I've been violated. There was no bruises or anything like that. I think you remember that one with Matt Rector, even though he had no right to do what he did, and it was his word against my word, it boiled down to. But I also see that this legislation can also be abused by individuals who are trying to get even if they were not happy with someone's decision or a disgruntled person with a breakup of another person, and it can be abused. But it all boils down to, like you said, credibility, and providing that to the court. Who is the court going to believe? But I think, it needs to be weighed out, and legislation like this, again, is a good deterrent from those who abuse the system in both categories. Mm-hmm. So I'm looking forward to, I'm supporting this legislation as well as the prior one, Bill 312 as well. But we also have to be conscious of what this may, what door it may open, if there's too much abuse of this. going to have to put some standards in place then.
Always a major concern. Always a major concern. There is nothing more devastating to an individual than a false allegation of sexual assault. A false allegation, particularly a false allegation of sexual assault on a minor. The advantage of my world is what we seek is to stop. We're not punitive in the civil courts, and particularly not in where I'm working. What we're seeking is prevention and protection. And the term itself here, protection, protective order. We're keeping someone safe. And if let's say, for example, it's a false allegation, what are the consequences ordinarily of a protective order? You can't go near them. I'm not putting people in jail. That's not what my vision is. My vision is to provide protection so people can sleep at night knowing that there is something out there that tells someone who's trying to take advantage of them or hurt them that they can't. And really that is the focus of all these protective orders, is to say, stop. It's not meant to be punitive at all. It's meant to say, stop. That's why in our protective orders, as I mentioned, we can obtain a protective order without an admission. The perpetrator doesn't have to admit in my world. They can agree to the terms of the protective order, and the protective order issues. So even in this aspect, an individual can say, and the example you gave, she's just mad because I want to break up with her. Well, here's your chance. Here's a court order that says you have to stay 500 feet away from her. So you can't go near her, and that means your relationship is over.
Yeah, but it's the stigma that comes with that. You know, as an individual, you're being accused of something that you've never done, and that pretty much can hurt a person's reputation, especially if they're, you know, seeking an employment somewhere, or, you know, it's the coconut telephone graphic on Guam that everybody gets that information, and now with social media, it becomes very hurtful in most ways.
Well, I would opine that with or without a protective order, that same effect is in play.
Yeah. No, I agree with the whole perspective of that, the protection part. I truly believe in that. But like I said, you know, if we need to keep an open eyes and watch very cautiously if this legislation does get through. But again, thank you, Mr. Summerflick, and I appreciate all your hard work toward this area of expertise. Thank you.
Thank you, Senator.
Thank you, Senator Tadigui. Vice Speaker Tina Barnes.
Sitos Masi, Madam Chair, and again, Attorney Summerflick, Dr. Sitos Masi, for your presentation and support today for these measures. I really, really appreciate your statements, especially on this bill and your testimony. I want to share with you, as I was talking to you a little bit earlier, that what may have not been needed back then because of our matrilineal society, how we were raised, close-knit family and all that, is truly needed today. And the other thing I wanted to bring up is, how do we bring the awareness to the community as a whole? Because some may not think that the crime is done, or the situation is they didn't do anything wrong. And I think legislations like this is a clear indication as a policymaker that no, if you violate, if you do this, you're going to go through you're going to go through the process of making sure that it doesn't happen. And I just think that this clearly states, right, that if there are violators out there, then there is a means where we can get the victims to get protected.
I think that this bill is time has come.
Yep.
You know, as a practitioner, as I've mentioned, there is nothing worse for me than to say to a victim, I don't recommend you do this. I don't recommend you seek an injunctive relief because there's a high likelihood you're going to seek financial relief. Again, what protective orders do is provide that protection. They're not seeking monetary damages. They're not seeking punishment. They're simply seeking to protect a victim from a perpetrator.
Yep. Yeah. So I really appreciate your comments today, and thank you, Madam Chair, for giving me the opportunity to thank Attorney Summerfleck. Sanamasi.
Situ's Masi, Vice Speaker. And I would like to invite the prime sponsor, Senator Mary Torres, to provide a closing statement on the bill.
Thank you, Madam Chair. I just want to express my gratitude again for your testimony today and all the dialogue that we had with regard to scenarios and any concerns with the bill. But fundamentally, what Bill 313 does is it provides a protective order process civilly for victims of non-consensual sexual assault or sexual penetration. And as you pointed out, and as I mentioned in my opening statement, oftentimes victims don't want anything more than to be left alone and to feel safe and to have peace of mind. And that is what this bill at its base does for victims. And oftentimes that is the first step. Once they gain control, feel that they're safe, then they can help themselves, seek other appropriate counseling or any remedy that they may have, but at the least they've secured themselves and found a place where they can feel that they will no longer be threatened by their victims. So, you know, that I think was the one thing that you highlighted, and really is the gist of this bill, is how do we protect them, provide them an easy access to a civil process that will award them a protective order straight away through a preponderance of evidence so that they can regain some control of their lives and some sense of security.
Very much so.
Yes, and thank you very much. Thank you, Madam Chair.
Thank you, Senator Torres. There being no additional individuals to present testimony today, the committee considers Bill 313-36 COR duly heard. The committee will remain open for submission of additional written testimony for the next 10 working days following this hearing, which is October 4th. Testimony can be sent via email to senatorterlajeguam@gmail.com or hand-delivered to the Speaker's office at the Guam Congress Building. The public hearing is now adjourned. The time is now 10:23. We will take a short recess for the next agenda item, which is Bill number 314-36 at 10:30. Situ's Masi.